Hello and welcome everyone to the main event this week. I'm Meeta Sani and I'm really pleased to be joined by Emma Griffiths. Hello, Emma.
Hi, Meeta. How are you? Hello, everybody.
Really well, thank you. Thanks for joining us today, Emma.
Thanks for having me. It's always a pleasure.
Well, I tell you what, with everything going on this year, these employment law changes that have come about, we've got the general election coming up and there's so many changes that could come in place if Labour come into power. We've got a lot to talk about, right? So I'm just going to do a little bit of housekeeping. But are you seeing that what's going on right now is busier, more impactful than usual?
We're hugely busy. I mean, we're hugely busy, and every HR person and every employment lawyer I talk to at the moment is hugely busy. There's all sorts of things going on. There are some changes, and everybody has to be aware of the changes that manage HR, and we'll cover them in this. Yeah. I'm not sure if that's entirely why we're busy. I just think there seems to be an awful lot going on in the people agenda across the board at the moment, which is good for HR and employment law.
Indeed. Well, we run these events to give our business community and our community support. We run them as a complimentary service, and we do that because we know the landscape, how challenging it is. As you said, people agendas are very busy and really important, right? Because retention and mental well-being and engagement and performance, I mean, it all rolls into how we can prevent challenges rather than having to deal with them when they come up. The more we can do that, the happier everyone is. And obviously from our perspective as a talent consultancy at the main group, we're about, yes, recruiting the right talent, but then retaining it and having them really engaged and positive. That's when we're really winning. So the housekeeping is really quick and simple, everyone. While you're jumping in and joining us, if this is your first time, we always run these events for about 45 minutes. We know time is precious. We're here to alleviate stress, not add to it. So about 45 minutes, Emma and I will be talking today. If there are questions that you specifically want answered, Emma has said that she will answer them in the room live. And that's really amazing. So thank you, Emma. This is, as I said, complimentary. So it's not often we get legal advice. And Emma is an employment law partner at Draper Lang. So she's very much at the rock face of everything we're talking about today. We've also got a chat box, and we've got a hello from the room already. Hi, Liz. I was just going to show everyone how easy it is, but Liz has already done that. So I'm just pushing a hello out there as well. Really simple. So please give us your thoughts, your questions, any scenarios you want answered, because the more we can tailor this session to challenges that are going on for you specifically, we know that this will answer so many other people's challenges as well. So please share and please let us know. And then finally, just to get a feel for what challenges you are facing, we've put a poll out, which we'd love for you to put your thoughts into, which are, the question is, what requests from your team or people are crossing your desk most frequently now as a manager or HR professional? And I suppose employment lawyers as well. So we've got the option of flexible working requests, and I know that's going to be a big part of today's conversation. Stress and mental health support and challenges, grievances. I've put L&D requests in because often people, when they're feeling under-supported or underdeveloped, they can come and say, I want to improve, I want training, I want investment in me. And then financial issues, whether it's salary reviews or cost of living crises, conversations. And then finally, carers leave, which I think is one of the case law updates. Is that right, Emma?
That's right. There's a new right to carers leave that we'll go through, but just coming in April.
Fantastic. So if everyone could put their thoughts into that would be great. At the moment, flexible working requests are over 50% of the room, and then financial issues are the next most frequently requested challenges at the moment. So we'll come back to that. But in the meantime, thank you. And we'll publish that at the end so everyone can get a feel for what's happening out there. And isn't it reassuring sometimes to know that we're not the only ones facing the challenges we're facing? I mean, Emma, you said it's busy out there. What's going on at the moment in your world?
Everything. Lots of different challenges. I think it's interesting that the two that are highlighted are flexible working and financial issues, because I think that's reflective of the world we're in, the cost of living, and post-COVID era. So I think the way we have work, where we work has changed. We all know that, and that feeds into the flexible working requests. And the financial issues, I think, is a combination of cost of living. Everything is going up, and wages aren't necessarily always going up accordingly. So I think people are asking those questions. And one of the reasons wages aren't always going up is businesses are also struggling and finding things tough. And we're doing redundancies and restructures for clients quite often as well. So I suspect businesses probably feel the pull of salary issues in both directions. Employees want to be paid more. They'd love to be able to pay them, but they can't because they're being pulled in the other end.
And I've seen some really unusual, I want to say unusual behaviors. I think in the last 5 years, nothing is unusual. You know, the way employers have to adapt, the way employees have changed their behaviors in the recruitment and retention space. The goalposts are shifting all the time, but we're finding at the moment that a lot of our clients are really having to button down the hatches, really watch every penny, really be tight on spending. And they are trying to invest in their people. They are trying to invest in equality and diversity support and mental health support. And, you know, with so much of the workforce, a previous webinar we did was around menopause care. You know, there's such a range of demographic in the workspace as well. It's a lot to think about. And we're just supporting Emma in a way that guides and advises on how, if clients are recruiting directly. I heard about a client yesterday who's got a freeze on for another year, and they're not even replacing maternity, or if somebody leaves the job, they're just reallocating. Yeah, and imagine the stress and pressure on the people in the business.
It's really, really tough. I have a lot of empathy for employers at the moment. It is really tough, but everybody's getting through the best they can, I think.
Yeah. So hopefully the work we're going to do now is going to help alleviate and support some of those challenges.
You know what? At the very least, if it doesn't help alleviate and support, it's knowledge, and knowledge is power. And also people, everybody's bought in. People are your biggest asset. I think almost everybody realizes, accepts that retention is cheaper than recruitment. I think everybody's bought into that as well. People are also probably one of every business's biggest risk if you get things wrong. And the changes today are relatively simple changes. But of course, as anything with employment law, if you get it wrong, then you do fall foul of legislation and potential claims, and also just employee engagement generally.
So, yes, it ripples, doesn't it? If employers get it wrong, it really does.
It does. So what I wanted to cover today is a couple of things. One, it's a big year for employment law because of the general election.
Yes.
So we don't know when the election is, and I suspect everybody's a little bit fed up of already of, if there's an election, this will happen. But actually, if Labour do win the general election, which of course is what's polled at the moment, there's a bit of a sea change coming, to say the least, in employment law. And I think employers should all be aware of those changes and just know what's coming up in case it's relevant. So I think at the end, we'll do a little bit of a wrap up, because it's all a bit what if, but I think it's important just to touch on it and keep people aware. The other stuff I wanted to cover is changes that happened starting this April, so this month. And there's some changes around flexible working, carers leave, family-friendly rules, and then a little bit of horizon scanning for a couple of things that are coming up in September and October, which is useful for employers to be aware.
And so much of it seems to be around supporting and retaining people in a more, I mean, I want to say humane. I mean, it's not like we're inhumane, but in a way that adds value to people's lives, makes their lives less stressful, more supportive.
Yeah, I think it's absolutely right. And if you look at flexible working, so I'll start with the flexible working changes. And the changes aren't huge, but you've got to know about them. But I think the bigger piece with flexible working is just we see these requests so much more. Because of COVID, because of the way we've all changed the way we work, because everybody's got their eyes open to the fact that people are not machines and they're rounded individuals with caring responsibilities, with childcare responsibilities, with frankly the fact that they would prefer to go to the gym first thing in the morning than sit on the tube, for example. So I think flexible working is just much more common. And one of the changes is it is now a default day one right to request flexible working. So there used to be a qualifying period of service before you could ask for flexible working. Now you can accept a full-time job, for argument's sake, arrive on day one and put in a flexible working request.
So I have a question on that, because this is definitely something that's come up for us whilst we're working with clients in the space of trying to attract talent, is that as an example, we have a role that is a 5-day-a-week role. The requirement is to be in 4 days a week, and the hours are 9 to 6. And we actually had a process where it went all the way through to offer, and the candidate in conversation said, look, actually, something's changed for me in life. I actually need to leave at 4:30 now because my childcare support is no longer available. I'd like to leave at 4:30, but then log on again from 5 to 6 from home. Perhaps even I don't mind doing an extra hour from home. Is that a possibility? So you say it's from day one, but I guess my question is, can it be in the interview stage as well? Where does the line?
Yeah, you've not got a statutory right at the interview stage, but yes, in reality, you can do it at the interview stage. And in an ideal world, you'd encourage people to make that request at an interview stage, wouldn't you? Because actually then everybody goes into it knowing what the expectation is. And also, if it's going to be a no, I think as a candidate, I'd prefer to know that before I got
can you imagine?
But I think a lot of people fear that they will be turned down because they've made that request. And that's in many cases probably a very legitimate fear. So they prefer to get the offer, then make the request and make the business feel like perhaps it's a bit harder for them to say no.
Yeah. And there's a change as well, isn't there, in whether employers can present a business, whereas previously employers just had to present a business case. Well, they didn't have to, but we advise present the business case if it's a no. That's changed as well now, hasn't it?
What has changed slightly is how the employee has to present. So the employee before had to say what effect they thought it would have on the business. And how they could overcome that challenge. They no longer have to do that, but I'd encourage any employee to do that, because if you want an employer to take your request seriously, then you've got to have thought about, well, this is my job, this is how it impacts my job, because that's going to be a discussion that takes place.
Yeah.
And in terms of the right to refuse, it is the same. Employers can still refuse. There are the same 8 statutory reasons that you have to use at least one of those in your refusal if you are refusing, which is things like impact on colleagues, the effect on client demand, etc. But as well as being able to sort of refuse for that, you have to be aware of the risk of indirect discrimination, because if it is somebody that's made a request for caring responsibilities, for example, or for their own disability or for childcare needs, there's always a risk that your refusal could lead to an indirect discrimination claim, and they can be very expensive, time consuming, risky, etc. So I think it's always sensible to really give meaningful consideration to the request. And if you want to refuse it and the circumstances are such that it could relate to anything along those lines, then it's always worth seeking some advice in the process. Have a chat with whoever you use for HR or employment.
Yeah. I read somewhere that there was a duty from an employer to explore options with the person requesting flexible work. Is that correct?
Yeah. If the answer is a yes, then you can just write out with your yes. If their answer is a no, you've got to meet with the employee, consult with them, have a conversation about what is and what isn't viable, genuinely consider before you say no. And I think what happened pre-COVID is, flexible working requests, employers often defaulted to a no, that's not possible. And I'd always encourage people, to meet with the employee, talk about it, try and understand it from both sides and trial it, because what's the worst that if you're not sure, trial it. What's the worst that can happen?
I love that. The trialing thing is sometimes, I think everyone forgets, they think it's this big extreme shift that can't be reversed, that is going to set a precedent, but actually it's not, is it? It's about sort of sensible partnership approach to seeing what works and what doesn't. Keep what works, let go of what doesn't.
Okay, exactly. And I think in terms of other changes, it's just worth ticking off. One is important, which is the decision period. So it used to be 3 months from the date you receive the request to the final date of your appeal. So you put in your request, you meet with the employee to discuss it, and you give them an outcome. If the outcome is no, they have the right of appeal. You meet with them as part of the appeal stage, and then you provide a written outcome. For that entire time period, that entire process, the time period used to be 3 months. Now it's 2. So from the date you receive the request to the end of the appeal is 2 months. In a lot of businesses, that's quite skinny, because you've got to find the person to do it, get the time in the diary, investigate it. That's not just the first stage. You've got to include the appeal stage in that as well. So as soon as you get the request, it's really important that managers know how to identify a flexible working request. And that's where training comes in, because requests are not always on a pretty form that HR have formulated and asked people to use. It's often an email to your line manager, for example, and it can't sit in a box with that I'll deal with that later for very long.
I mean, and the room right now is 61% have said that flexible working requests are there. I mean, if you reflect that into our world in this room, the London and the country, that's a lot of time and headspace and changing all the time for an employer to have to be. This is literally a full-time job.
It's busy, but I think most people that make a flexible working request want to make it work. And the value of giving someone flexibility in terms of retention is absolutely huge, because you get so much loyalty. So I'd genuinely open mind, trial it. If it's agreed, it's important to know it's a permanent change to contract. So if it is agreed, it is a permanent change. And therefore, if you want to go back on it, then it involves a period of consultation and lots of other things. You can't just change your mind.
So, for example, you could agree on something, say, right, let's trial it for 3 months. We'll have a review a couple of weeks before the 3 months is over. At that point, any party can say it's not working for them, and then you go back to the drawing board. Or if it does work, then you change the contract.
Yeah, and it becomes a permanent change. But for a trial, both parties have got to agree that they're willing to trial it, obviously. Yeah. Otherwise, it's not a goer. And the other change is, and this is a bit of a false one to my mind, but employees were previously only allowed to make one flexible request in a 12-month period, obviously to stop the idea of people chopping and changing. Now people can make 2 requests in a 12-month period. But again, if somebody makes a third request, and if they're making a request every week, okay, fine, tell them no, and you've got to have some stability. But if somebody's life is changing and they need flexibility and they make more than 2 requests, then my view is always good employment practice would be to hear them.
Yeah, I'd love to hear from the room if anyone has denied a flexible request, because as you said, Emma, the spirit of partnership, the spirit of collaboration, and being more holistic in the way we support our people has really meant that I think a lot of employers find it really hard. But if there's, I'd love to hear from the room that you're here, you're hearing us, because we've got a couple of hellos, but we still would love a bit more interaction just to let us know you're out there and it all is good. But has anyone said no to a flexible working request, and what was the outcome? I'd really love to know, because I think for us, Emma, as much as we want everyone to be able to work together, there are going to be people in here saying,
while people are typing their answers, I've advised on no's many times over the years, and there are still no's, and there are still no's that I absolutely back as reasonable. And it's often more, if you think of an office context of professional services, I think it's a bit harder to say no, because actually if someone's saying, in the example you gave, well, I log back on in the evening and that half an hour that I'm out picking up children or critical, it's harder to say no, I think, realistically. If, however, you're on the shop floor of a factory, if you're on the shop floor of a shop, and you need that business to have people in it at set times, and you can't cover from somebody else all the time, or it would be unreasonable to always expect. So, for example, you don't want to do an early open or a late close because of childcare, and there's only one other person that can do it, then maybe it is unreasonable to put that always on that one other person. So no is perfectly valid as a reason. And we're not getting any comments. I'm wondering if anyone said yes. Can we do a converse question? Has anyone said yes? And how? Yes. How does it work?
There's definitely a lot of people in the room today. So let us know if you have. That would be good. Thank you. Okay. So why did you say that you think the 2 requests, or someone does a third, is a false one? Why is that?
Oh, no, I said, I mean, look, most employees want to work, get paid, do their job, go home, right? Yeah. Some people are annoying and want to make life difficult. So some people might make a request one week and make a request another week and make a request the 3rd week and make a request the 4th week. If that happens, I think, there's 2 requests in a 12-month period, stand firm on it. But if you have somebody that has a genuine, 3 reasons in a year to change, then don't refuse simply because the statutory rules are you're only allowed 2 in a year. Also on flexible working, action point, most employers will have a flexible working policy now. So action point is go to your flexible working policies and change those points. So change your eligibility. It should be from day one. Change the fact it shouldn't be 1 year in a year it should be 2. Change the decision period from 3 months to 2 months, and message it out there, train people. We have got a comment on there, Rita.
Oh, well done. Brilliant. Thank you, Sue. So Sue has a comment. We suggested that they work their 3-month probation period, so they've learnt the role. So this must have been a day one request, so that they've learnt their role and we're both comfortable that they are performing, and then we discuss it. Is this still an option?
Yeah, I think if the employee is willing to agree to that, then that's sensible. I suppose it's akin to a trial. Well, it is, isn't it? It's a trial period. Yeah. So I think just make sure it's documented fully what you've agreed to do and when you will revisit, and make sure you do actually revisit.
Exactly. Diarise it. Talk about it the week before. Say, hey, we've got your review coming up. Come with thoughts and notes, and I'll do the same. Because again, people feel if they have to remind you, it starts to feel like they're not important. We've got another comment here from Janice. Yes, we have and agree in an office environment. And with hybrid working, it is easier to accept. Previously, I've also partially accepted a request or come to an agreement on a change that is acceptable to both. We would always do it for a trial period first. Brilliant. Thank you, Janice, and thank you, Sue.
And I think that's a relevant point, Janice. I think a lot of people used to put in a request that was more than they wanted to get what they wanted, if you like. So it's a bit of a negotiating tactic, I want to work 3 days a week at home and they really want to work 2. So you have that discussion and partially agree and come to a compromise.
Yeah.
So
do you still think people do that? They over-egg the request?
I don't think as much, but I'm sure people must, surely.
Yeah. It's appetite for negotiation, isn't it, really?
Yeah, and I think people are much less afraid to ask when they're joining a role, because there is now such an expectation that particularly office roles will be hybrid. So people, that's the standard question. I'm sure you find it in recruitment.
Oh, less than 10%, maybe even less than sort of 5% of roles are 5 days full-time in the office. And find the talent pool of availability, if you want that, is so narrow that it can make for quite an impossible. We do it, and we're very successful at it because that's our job. We've got the network and we mine. It's what I think the biggest challenge I always advise my clients is, if somebody is in 5 days, they will be getting their head turned by companies that say we'll let you work hybrid. So this is the challenge. But we work predominantly with SME organizations where they are more flexible and open. But I think that's something to bear in mind. As you said, retention is far cheaper and time effective, less time consuming than recruitment. So
definitely. Shall we move on and look at redundancy protection that's changed?
Yes, let's do that.
So
this is maternity.
This is maternity and also adoption and shared parental leave returners. So there's a few family-friendly changes that have come in. Let me do a really quick one on paternity leave, just because I think people perhaps missed that one, and it's really minor. But again, the action point is get your policies out and just make sure that they're up to date. The statutory paternity leave of 2 weeks, you can now take it in non-consecutive blocks. So you can do a week at the start, week at the end if you want to. And you take it within 52 weeks of birth or adoption placement. So within the first year that the child's with you. Before it was 56 days. So that's the difference. And there's a slight difference in terms of, the amount of notification you have to give. So there's just a couple of small technical tweaks, but you want to get it right, because if somebody's on maternity leave, you want to make sure that they're, you're matching what they're entitled to. So just a small one on that, but make sure you just double check your policies. The bigger one for people to be aware of is redundancy protection. So the starting point for this, many employers aren't aware of to start with. Firstly, there is a sort of myth that you can't be made redundant when you're on maternity leave. Firstly, you can be made redundant when you're on maternity leave. If there is a reduction in need, if there isn't your job anymore, you can. There's always the risk that somebody's going to say it's because I'm on maternity leave and it's discriminatory. But if you genuinely have to make a redundancy while somebody's on maternity leave, that is lawful. However, somebody on maternity leave has protection. And the protection that they have is not that they can't be made redundant. It's that if there is a suitable alternative role, they are automatically given that role. So, for example, if you have somebody in a particular role and they're getting rid of their role, so that role is no longer going to exist, but there's an alternative role that would be suitable for that person, they could step into that, they could do that job. Even if 3 other people could do that job, as well that are also at risk of redundancy and that are maybe even more qualified than the person on maternity leave. The person on maternity leave must be given that job. That is the protection that exists when you're at risk of redundancy. That's the current law. Okay. So that's the current law. That doesn't change.
Yeah.
The reason that was there, obviously, is to try and prevent people getting rid of people when they're on maternity leave and give them that extra protection.
Yeah.
What happened in practice is somebody would go on maternity leave. They'd be kind of out of sight, out of mind of a business for the majority of the year. And the business would decide that they didn't really need that person anymore. So they'd want to make the redundancy of that role, that person, whatever. It should be a role, not a person, but either way. But they wouldn't do it on redundancy. They'd wait until they were back in the building, almost day one, month one, whatever. And then they do the redundancy because the maternity protection didn't apply. That right to be given the alternative role. So businesses would strategically pause a redundancy. And not so much, if it's a big collective redundancy with tens of people affected, then you're not going to pause it for one. Yeah. But where there is a smaller business and it's a small number, businesses strategically pause redundancies until that person walks back through the door. They no longer get the protection. So right now you're at risk of redundancy. And there's little you can do in related to maternity. So that's been recognised. So the change in the law is now that protection applies for 18 months after birth. Or 18 months after the child's placed for adoption, so that you've got your 12 months maternity, you walk back into the building and you've got 6 more months to remind everybody you exist, I think, frankly. But people are going to miss that protection because they've had someone back in. It's genuinely nothing to do with maternity. That's not even at the forefront of their mind. Put somebody at risk of redundancy and forget that person now has the right. So that protection now applies to people that have had babies that are on maternity, people that have had children placed with them for adoption, and people that have taken more than 6 weeks consecutive shared parental leave. So men and women, it's going to apply equally because one could be the primary adopter, for example. And also it's going to apply from the point that the employer knows that you're pregnant. So you've got that protection right from the minute somebody knows that somebody's pregnant, right the way through until 18 months after the child's born. Now, the policy behind it makes sense. Absolutely. It does. Yeah. The logistics of managing it as an employer is interesting. Particularly when you've got a really big workforce. So I've spoken to clients about this and how they're managing it, and some have got family-friendly trackers, so they know who's on leave when they're due back, when their protection ends, not because they're trying any sort of sinister moves on redundancy, just because and they are an industry where they do make redundancies relatively frequently, this particular client, just because then they know that person's going to have the protection. Because it's automatically going to be discrimination if you fall foul of that. So it's quite a big one to get your head around. So I think action points are twofold. One, have a little look at all of your family-friendly policies and see if they mention redundancy. If they mention redundancy, you need to update it with this new information. Most family-friendly policies actually don't mention redundancy, so you won't need to make any changes to your policy. But what you do need to do is, as a HR team, as a management team, you need to be aware of it, and you need to know if redundancies are being planned. This is something you've got to factor in when you're looking at the at-risk people, at-risk roles. You sense check that. So it's quite a big one.
And if you are from a big space and you think, how are my people going to get this across and retain it, we are doing a lot of training around this at the moment, and we're just getting out in front of people managers and HR professionals and making sure everyone's up to speed with that, because the cost of training versus the cost of getting it wrong or becoming case law, just money and time and reputation.
I'm a huge advocate of training. I'm a huge advocate of getting out there, training people, training your managers, cascading it down, messaging out there. It's so important. It's so important.
Yeah. And it's a really positive message for the employees to see this happening. It doesn't, it's double impact. It prevents future challenges, but it also buoys up people in the organisation to feel, hey, we're being looked out for, and that's important.
Yeah, I do an awful lot of equality, diversity and inclusion training, and I think the message, as well as just the training and the importance of the content, actually the message to employees is we care as an organisation. We value diversity. We don't want discrimination. Yeah. We are going to deal with it. You're in a safe space. And it's really important, I think.
Yeah, we've identified 4 pillars of purpose in the work we do, not just being good for the organisations we work with, not just being good for the world, but not just good in the world, but being good for the world as well. And equality and diversity is one of those 4 pillars. And you're absolutely right. Just every employer we speak to, when we explain to them that what we do with you will also enhance your EDIB process, and they feed that back to their people, it's just really powerful that people feel that it's one thing having that policy, it's another thing putting it into practice. So if you can put it into practice for when you hire, then when you induct and retain and train, it's so powerful. We have one client that does it every year without fail.
No, I went to and it should be every year. EDI should be every year, and there's actually an employment tribunal case. I think we might have talked about it on a previous webinar actually. And the case, the employee who had made discriminatory remarks had been trained 18 months previously, and the judge said that training was stale. It was too far in the past. So at least a year.
Practice would be once a year anyway. Yeah,
absolutely.
Not statutory requirement, but best practice.
Yeah, absolute best practice.
Yeah.
And I think interesting what you said about policies. I went to a book signing with my daughter at the weekend, and the author was saying basically, thanks everybody for believing in me, because if you didn't believe in me and buy my books, then my book would essentially be a Word document on my computer, and it would be nothing to anyone. And I thought that's such a good analogy with policies, because actually there's no point. They're in a book, they're on the internet. If they're not engaged with, trained and shared,
it's just wallpaper. It's just wallpaper.
Exactly.
You don't know it anymore. Absolutely. Right. Okay. So we've got about 10 or 15 minutes left.
Brilliant.
What else would we be?
I'll do you a few quick ones. So carers leave.
Yes, that was one of the options in our poll.
Yeah. Did anyone come back on carers leave?
Not yet.
And I think that's a reflection on the fact it is so new. So it is a new statutory right. It came in from the 6th of April this year. Okay. It's worth getting yourself as an employer just a brief policy on carers leave. It's only a page, 2 pages of A4. I can supply them if you haven't got anybody else that can. Fairly simple. Basically, anybody that's a carer can request 1 week's unpaid leave a year. So in a rolling 12-month period for their caring responsibilities. So it's a day 1 right, like flexible working is now.
Yeah,
it applies if you've got a dependent who's got a long-term care need and you need to be absent from work basically to provide care or to arrange care. You can do it a full week. You can do non-consecutive days. You can do half days. It's unpaid. I'd encourage all employers, if you can, if somebody's genuinely caring, if you can do it paid, please do, because that's just the right thing to do in terms of retention. And you've got to give notice of the intention to take carers leave. An employer can can postpone the request. You can't refuse it, but you can postpone it if the timing's not quite right for the business. But again, it's one of those things, discussion agreement, if you can do the right thing. I always think carers predominantly are working far harder at home than they are at work, because it's such a draining and all-encompassing responsibility. So if you can do anything as an employer to make it a bit easier, do.
Yeah, again, it goes a long way, not just morally, but from a commercial perspective, you'll retain and get so much more appreciation and return on that.
Absolutely. But the action point there is get yourself a policy, and if someone asks for carers leave, just don't go, oh, what's that? Just talk to them and get it sorted. Holiday and working time. So working time regulations.
Yes.
There are a few changes that didn't do much other than put case law from Europe into UK statute law.
Okay.
All of the Brexit stuff. So I won't go through those because the law hasn't changed. Just the way it's been written has been changed.
Okay.
But the law has changed in one thing, which is a result of Brexit, which is if you have irregular hours workers or part-year workers, do you aware of rolled up holiday pay and the drama around paying people rolled up holiday pay?
Yeah, because we run a temporaries and interims desk. So please, yeah. But this one for me was quite interesting because, we've got people that want flexibility, want ad hoc opportunity to jump in, jump out. But this is the opposite of that, right? This is about,
I think, making admin of payroll easier, because when you have somebody come in and do a couple of days here, a couple of days there, but you're not allowed to give them rolled up holiday pay. You've got to calculate holiday, look back over however long they've worked and try and make the calculation. It's just a nightmare. I think what you can do now, some people just did all the way through, but they weren't allowed to, is do rolled up holiday pay. So you pay somebody their hourly rate and then 12.0770. Hang on, I'm going to find the number. 12.07% on top as their holiday allowance.
And that's just if it's statutory, right? If the company gives more, then it's got to be a high percentage.
Yeah, then if contractually, if you've agreed more, then you have to obviously give the appropriate percentage for holiday pay. But the principle is now you don't have to say, here is your holiday. You must take holiday leave for us. You can just say, right, here's your rate of pay, and we'll give you the percentage of holiday now upfront, so you've got it. What you do need to make sure if you're doing that is obviously you still have holiday is primarily health and safety. That's where it derives from.
Yeah, so it's taking that time.
Yeah, exactly. And the reason the rolled up holiday pay was made unlawful by the European courts was because it was felt it was a deterrent. So people would carry on getting paid, work 52 weeks of a year, get paid their holiday, get paid for working, get more money, but not take a break. So now as an employer, you just really need to make sure that if you have a casual worker that is there for a long period of time, that they are actually taking a break as well.
Yeah. And it would be about dropping them a message to say, hey, I've noticed you've worked 8 weeks solid or 3 months, whatever it is. But you can't, whereas I know we used to have conversations where people would, put all their holiday to the end of the year. And from a commercial perspective, it was difficult because everybody would want to have the same time off or over summer. But on a health and safety perspective, it's not healthy to not have holiday for 11 months. And then, for example, so how can an employer get over that?
Conversation with people. You can prescribe when people can take holiday. So there are rules under the working time regulations where you can give notice that somebody must take holiday. So as long as you give double the notice of the holiday you want them to take. So if you give them 2 weeks notice of a 1 week holiday, you can prescribe that. But that's not healthy or right for anyone. But I think having that conversation and saying, we do need to take some time off here. And also if it's a casual or part year worker, presumably depending on the hours they're doing, you may well be building in a break anyway, or you could withhold some work for that time if you really felt health and safety obligation. It's just aware of really
working together.
Yeah.
So is that linked to the new rights to request a predictable working pattern then? Is that?
No, actually, but it's sort of linked. But I was actually going to move on to these sort of my 2 horizon scanning points, which are for September and October. So there's 2. One is the right to request more predictable terms. The other is preventing sexual harassment. If I do those both really quickly, because I think we're going to run out of time and I think the general election stuff's quite interesting. I'll very quickly do these. But if people have got questions they want to message afterwards, I'm really happy to answer.
Yeah, we're actually going to send out the recording for everyone and we'll put Emma and my contact details on there. And we're on LinkedIn. We're always putting things on there. So, yeah, we're here to help. Go for it, Emma. Sorry.
No, it's great. So September, there will be the right for workers to request more predictable terms. So it's a new statutory right. It's a right to request. So it's a similar format to flexible working. You can say no. Applications got to be dealt with in a reasonable manner and within a month of receiving it. There's no obligation to agree, but it's basically for workers and agency workers who've got at least 26 weeks service. So again, there's that sort of 6-month mark. They've got an unpredictable working pattern, or if they're on a fixed term contract of a year or less. So they're able to say, I want a more predictable pattern in terms of my hours work, my days and work. And if they're on a fixed term, they're allowed to say, I want a permanent contract. So to be honest, this is all stuff that people have always, without a statutory right, people, if they wanted to ask, they can ask. And you want to say no, then you can say no. But it's just about sense checking it, doing it in line with the process that will become law in September, and being aware of indirect discrimination. So it's again, as you said, it's more about the way we work in communication than anything else, I think. And the other one in horizon scanning is October, preventing sexual harassment. So there'll be a new law for employers to take reasonable steps to prevent sexual harassment.
Okay.
So again, it's part of your ED&I training. So it's getting out there and making sure that people know that it's not acceptable. It's also looking at, third parties and the way they treat your staff. So things that you could do is obviously, make sure you've got a zero tolerance approach and communicate that out there. Review your anti-harassment policies and procedures, communicate them, be clear on what is and what isn't acceptable, address the word banter that people like to use.
Give everything and it doesn't.
Yeah, just setting that culture and being very clear that, again, safe space if people need to request, and they will actually deal with it. But that's
the amount of communication training we do is amazing, because really everything comes down to that. And as an employer, to be able to have a register of everything you've been through, and as you said, Emma, annually is ideal, because that case law said 18 months was stale, and therefore put the responsibility back in the employer's space. First of all, it's best practice, but also it just gives everyone clarity on what good looks like in our world and what is and isn't acceptable.
Yeah, and I think the more you do it, the more the drumbeat goes into people's heads. You see it over and over again. It catches your new joiners as well. It just sets the tone. It's important.
Yeah. Brilliant.
Shall I do a little bit of what Labour say they'll do in their first 100 days?
Yes.
So,
okay.
There's a lot. There's a few long terms, and there's some. Obviously there's still no manifesto. So when the manifesto comes out, then this will become a little bit more clear. But stuff that they previously communicated they would do in their first 100 days. First one is remove unfair dismissal qualifying periods. So right now, you can only claim unfair dismissal, normal unfair dismissal, if you've been employed for 2 years.
Yeah. The
proposal is to remove those qualifying periods. Before the 2 years, some people might remember it used to be a year. And I think a lot of people thought Labour might go back to a year, but they said they'd remove them altogether. There was quite a bit of outcry in the press when that was said. And then somebody from the front benches kind of very quickly went, well, you would be allowed a reasonable trial period first. So I wonder if it might be a 6 month, but either way, it's going to shrink down from 2 years to unfair dismissal claims. And I think
that's going to mean clients will hire flexibly and use temp to perm options and contract options rather than hiring permanently. I don't know if it's in the best interest of.
Yeah, it's interesting. It's a good insight. I think it'll be a bit of that. I think from a lawyer's perspective, there'll potentially be more claims, but more straightforward claims, because right now what people do is you can claim discrimination from day one, or automatic unfair dismissal. So if you've been unfairly dismissed because of whistleblowing, for example, they're really complicated claims to defend.
Yeah.
People will start putting in some more straightforward unfair dismissal claims, I think, rather than the complex ones. But you're quite right. It means the way people hire might change.
Might do.
Yeah, you're right. Another one is outlaw fire and rehire. So, the P&O stuff, basically, where people are trying to, where they will fire somebody and offer them a new job on new terms. They said they'll outlaw that. I find that interesting because I think the P&O example is one of the worst examples of employer behaviour I think anybody's seen.
Ever. Yeah.
Yeah, absolutely. And that's why there's such an outcry. But there are genuinely times where employers need to change terms. And if you haven't got a mechanism for that, I think it's problematic. So it will be interesting to see. The intentions are clear. ACAS have just put out in March, beginning of March, I think, they put out new guidance on fire and rehire and how to do it well. I think that's probably more sustainable than outlawing it. But the current, the language has been outlawed, so it'll be interesting to see how that comes about if it does. Then we've got greater discrimination protections, so more to address the gender pay gap, looking at publishing ethnicity and gender pay gap stats as well.
Okay.
So really making it, and there's talk about later in a parliament looking at socioeconomic type stats as well. So really get equity across the piece, which is
absolutely really social impact. That's one of our other pillars of purpose, helping people that come from backgrounds that they need to the equanimity as well.
Yeah, absolutely. And then other one sort of is perhaps more traditionally Labour, which is greater trade union rights to organise meaningfully. And creating the one I think I like the most of all, creating a single status of worker for everybody but the genuinely self-employed. So there's a slightly strange status at the moment where you have workers, you have employees, and you can have self-employed. But the worker-employee distinction is a little bit of a nonsense and confuses everybody. So I think just a bit of simplification there is good. And ultimately, in the long term, talking about banning 0 hours contracts, the right to disconnect from work, just making more of basically an equitable and a work-life balance is what their piece looks like. But there could be some really interesting, quick initial changes that are going to keep us all on our toes.
Wow, Emma. Wow, that was amazing. Thank you for the insight, the really straightforward way you explain it. That is so helpful, because I think everyone watching can absorb that and apply it and get ahead of themselves. And as I said, if there's anything that we haven't covered off, we didn't get too many questions in the room, so hopefully everyone has taken
away.
No, we're still in here. So, but hopefully what that means is that the recording, and I would say share this recording with colleagues. If you know there's somebody who needs to be aware but isn't open, say, listen, you've got to watch this, you've got to see why I'm making such a big thing of this. And so use these videos, share them, the recordings. And also, as we said earlier, Emma and I are available outside of this room, and please don't hold back. We do some great work, and we do some of it pro bono as well, so happy to help and here to help.
Yeah, it's such it is a whistle stop. There's a lot, but as Mita says, if I'm very happy to take questions or have a chat with anybody afterwards if there's any follow-ups.
Fantastic. Emma, thank you so much.
Thanks for having me.
And I think everything we've talked about, we better get another one in the diary, and so we can almost have a follow-up, because there will be case law that evolves and other changes. And as you said, with the horizon setting and most likely Labour coming in, we'll definitely have more awareness to raise and policies to change. Quite interestingly, in answer to the poll, 57% remains flexible working. 2 second place stress, mental health challenges, and financial issues. So really probably linked into one there, because a lot of the financial challenges are causing. And also, as we said, where employers are condensing teams and dividing work amongst the existing team, that's just going to add more and more pressure. Grievances and L&D requests and at the also have some votes, but not the highest. And then carers leave, as you said, right now, Emma, people aren't probably even aware of it because it's just come in, so that didn't have any votes. But let's hope that people get access to that and are able to be supported, so that everyone here can retain and create engagement, positivity, and success going forward. Right, well, that's it for now. Thanks to everyone for joining. Emma, thank you again. And the main event will be back in another week. So we'll look forward to seeing everyone then.
Bye, everybody. Thanks for having me.
Bye.